class. I'm here to teach you Texas employment law at will and some exception to the Texas employment law at will that allows you to file lawsuits. We've all heard about employment at will, but did you know that it is a pretty common law that applies to many states besides Texas? Employment at will means that you work for your employer. There's no promise that you have a guaranteed job. Again, on the other side, there's no guarantee, there's no promise that you have to keep that person for a long time. So either party, the employer or the employee, can terminate that relationship at any time. So it's a very friendly business rule because it allows employers to hire on folks without the trouble of justifying a termination. So there's a lot of myth that comes into play. A lot of people think that, hey, before my employer can fire me, they must give me a good reason. They give me a legitimate reason. If they cannot, then they can't fire me. Well, that is different. Employment at will means they can fire you for any reason they want, even a bad reason or no reason. So that's a pretty common misconception I'm going to put to bed right now. In Texas, employment at will means that an employer can fire you for any reason they want, even a bad reason. You, as an employee, are allowed to quit at any time. And so let's discuss now the exception to the rule. First is, do you have a contract? If there's an existing contract that talks about maybe a 1-year term or something like that, and in that situation, the employer cannot fire you until you finish that 1 year. On the other hand, you can't quit until you have served the full 1 year tenure of that contract. So take a look at the contract if you have one, and does it have a promise of a fixed period of time that the employment agreement will last. A contract is one way to modify the employment at will, meaning you've changed it. Now you're married together. You cannot break that bond because if you did, you will break the contract. And you could be sued for it, either side. So if you have a contract, an employment contract, and you quit and you leave, your employer can sue you for breaking that contract and vice versa. The other exception is that you can fire an employee for any reason at all under employment at will, except for an illegal reason. An illegal reason might be that employee was a whistleblower. That employee complained about discrimination or some type of protected activity because that is protected by law. You can't retaliate against that person. Are you firing someone because of a protected characteristic, such as their medical condition, disability, having taken Family Medical Leave Act, having taken time off for military service, or you're firing them because of a discriminatory reason, such as race, national origin, age, sex, or some other characteristic that's defined by the law. There's a lot of different examples of that, but they're micro, small niche area. For example, you might fire someone because of their genetics, their DNA. There's an actual law that says you can't require people to submit to DNA tests and fire them. Or you fire someone because they refuse to take a polygraph examination. So when you take all of those protected characteristics together, you can't fire them for those reasons because there's statutory prohibition against that. Now, when you think about all these things, you're probably going to say, where do I find out more information about this? Well, there's federal laws that apply, there is state law that applies, and there are what we call National Labor Relations Board that applies. You just have to figure out what is it that is of concern, what is the protected characteristics, and that law would apply. So one good source is the EEOC.gov. That's a great website, or the Department of Labor.gov, and also the Texas Workforce Commission And of course, you can also visit my website, tranlf.com, for more information. But overall, a simple Google will let you know which characteristic is protected, and then you will then go into more detail and figure out what specific prohibition applies. So, in summary, I've just covered Texas employment at will, some exception to the Texas employment at will that allows you as an employee to file a lawsuit. One thing I do want to talk to you about is the statute of limitation. The statute of limitation is very specific to all of these things. Sometimes it's 30 days, 90 days, sometimes it's 180 days or 300 days. It all depends on which statute you're suing under. So it's really important to do your proper research or talk to employment lawyer that specializes in employment law or labor law in Texas, or is involved in representing workers on a federal level, because whether you sue under federal law or state law is very specific to where the headquarters is of the company that you are planning to sue. Also, it's where you worked, where the act occurred. So we'll talk about that later in another presentation. All right, you have a good day.